Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondac webinar in association with Goodman Derrick, which focuses on construction and engineering disputes with an eye on the dual issues of Brexit and COVID and the future of construction. We are joined by a brilliant panel to lead you through today's discussion. Richard Bailey leads the construction, engineering and international arbitration team at Goodman Derrick, providing specialist advice to contractors, subcontractors, property owners, developers, consultants, and project stakeholders. Lachlan Steer is an experienced and well-rounded construction lawyer. He provides specialist dispute avoidance, resolution advice, and non-contentious advice to an array of clients, including employers, architects, contractors, and subcontractors. Now, before we get started, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. I would now like to hand you over to our panelists to begin today's webinar. Thank you.
All right, good afternoon. Thank you all for coming today. It's our great pleasure to be speaking to you this afternoon and this morning for some of you, no doubt. Very quick introduction before we get into the meat of our session. There's a very quick profile for both myself and Lachlan. Apologies in my case for the slight lockdown haircut. It's one of the advantages of not having that much hair, but that is our profile. If you can move on to the next slide. Now I'm going to take you through the agenda. We're going to be dealing with 6 topics today. The first area is common claims and current challenges created by COVID and the UK's new status following, almost not new anymore, following the 1st of January of this year when the UK formally left the European Union. We'll then be turning to dispute resolution options, litigation and the alternatives to it, including ways and means of dispute avoidance, both UK and domestic, and arbitration, both UK, domestic and international, and also mediation and adjudication, and to an extent, dispute boards. Then we'll turn to adjudication update. That's what's the best way to get paid. That's UK and a number of jurisdictions outside of the UK, of course, today. Moving on to getting paid and retaining money in pressurised times, and how to protect yourself against insolvency issues when you're operating in the construction industry. And finally, how we, Goodman Derrick, can help, and examples of our successes, which we will run you through. I'm now going to hand over to Lachlan.
Thank you, Richard. So the title of today's talk is Brexit, COVID, what next? In the last year in this country alone, we've had a plague, power cuts and floods. So I'm half expecting a swarm of locusts. But seriously though, cast your minds back to the beginnings of 2020. I'm sure we'd all brought the new year in properly. Our departure from the EU was a way off, and a little something called COVID-19 was making waves in Europe. The government, of course, assured us everything was in hand. When it hit, I'm sure most of us simply thought that we'd be at home for a few months before our life could resume as normal. This, of course, was not the case. So we fast forward a year to a couple of months ago, January 2021, and where are we? Well, we have our trade deal, which was agreed in classic British just-in-time style on Christmas Eve, and an overhaul to our immigration system as well. This latter point is of particular interest given the reliance of the London construction market on foreign labour, with some estimates putting this as high as a third of the workforce. We have no obvious additional direct costs to businesses, although there do look to be some substantial indirect costs, such as the rules of origin rules, whereby products must be able to identify their national source. I'm sure we can all remember as well the unfortunate case of the English lorry driver who got his ham sandwich confiscated by the Dutch border force. We also have emergency COVID-19 legislation, which has been introduced, but of course, this has been predominantly silent as to the construction industry. So what has all this meant? Well, inevitably, projects have taken longer and ended up costing more. Good news for disputes lawyers, but of course, bad news for the projects themselves. So what are some of the issues and the grounds for dispute? Well, there has been a rising cost of materials. Several of my clients have actually said that they felt a sense of relief that they hadn't taken on some projects on the basis that they would actually not be viable now because of this additional cost. Further, the effect of implementing the regulations, and of course, we're talking about the regulations here, not then the guidance, not the legislation. Of course, more on that later in that distinction. And simply dealing with a COVID secure workplace, adapting your working practices and isolating on site, it's all becoming a bit more difficult. Of course, the inability to source labour is another potential issue which can be brought on by both Brexit and COVID. We also have here supplier shutdown and cost of replacement goods. A number of projects that we've been involved with have suffered this, and of course that immediately puts the contractor on the back foot because there is a delay outside of their control. So what does all of this mean in terms of liability? Well, it's the interpretation of the contracts and who bears the risk of the impacts to cost and the date for completion. And really all of this feeds into disputes that arise on both those terms. So what do the contracts say? Well, the unamended JCT and NEC contracts offer little comfort. In terms of force majeure, which is worth focusing on, given that actually it was amongst the items listed from some of the questions that have been pre-submitted, and also certainly we've seen a lot of claims relating to force majeure coming across our desks in relation to defences for liquidated damages on recent projects. So force majeure is of course a legal term, not to be confused with the 80s New Wave band of the same name. Now, it is a relevant event under the JCT. It is a compensation event under the NEC form of contract, but is not defined under either. I mentioned the distinction between legislation and guidance earlier, because of course, early doors, some individuals and companies were trying to argue that adhering to the coronavirus regulations and legislation was the same as adhering to the working practice guidance. And of course, that wasn't the case. And I don't think anyone has succeeded in arguing that for an extension of time. And the relevant clause there under design and build 22612, and of course optional clause under the ECC X2, which of course would have to be included anyway. So the result of this is parties increasingly amending their contracts in a bespoke way. So force majeure as a concept of COVID-19 and Brexit. COVID-19, is it grounds for a claim for force majeure? Well, quite possibly. It certainly wasn't anticipated by the parties. It certainly was beyond the reasonable control of the parties, but we don't have any case law. Even with the SARS and Ebola epidemics and everything else, we don't have any case law for our jurisdictions that will confirm that, but it seems quite possible. In terms of arguing the point for force majeure, you need to look at the fact that an event had caused you to delay or not be able to perform your obligations, that those obligations were beyond your reasonable control, and that there were no reasonable steps that could be taken to mitigate. And I think this last point is one of the areas that could be a stumbling block, because of course mitigation or lack thereof could have a big impact on your entitlement to claim that extension of time. So COVID, quite possibly. In terms of Brexit, well, it's likely a different debate, and this is in reference to two cases. The first one of which is more recent, and that's Canary Wharf and the European Medical Agency, and they had a 25-year lease for £500 million, and tried to say that as a result of the Brexit referendum, the lease had been frustrated, and the court said, no, we're not having any of that, simply because your obligations have become economically or commercially more burdensome. Does not mean that they have radically changed or become impossible. So unlike COVID, the courts have given us an indication of how they're likely to treat Brexit, and therefore there is that key distinction there. And just as a reminder, force majeure is a contractual term and not one established by common law. So you always must look at the contract to see what it says and what are your obligations and or rights thereunder. Over back to Richard now.
Thank you, Lachlan. I thought I'd better turn my camera off so as not to distract anyone. Right, so I'm talking to you in this section about dispute resolution options. Obviously, it will come as no surprise to anybody that somebody who's head of a group that deals with construction, litigation is one of my favourite subjects. Obviously not one I speak to people about in the pub, even if they have only just reopened. So you've got other topics to talk about, catching up after a year after what Lachlan's been talking about. No one says no access to pubs is a force majeure event. Anyway, dispute avoidance, that's the name of the game nowadays. Starting with how to avoid dispute, just a couple of things here, and this is something which ghosting, which for those who are younger does not mean ignoring on WhatsApp or TikTok or whatever particular social media you happen to be on and not talking to your friends. This is more important. This is where we, the lawyers, sit behind you, the client, or behind the client, and we write letters and assist with the writing of letters. You can usually tell when a lawyer has ghosted a letter for their client, because there'll be some strange phrase that could only come from someone with a certain legal input. But personally, I always try and make mine sound like they came from my client. But it's important to make sure that you're actually properly advising and properly you're able to put the best foot forward so that you can avoid the disputes before they can erupt into the expensive litigation. So it's really about putting your best foot forward. Now, litigation, just the initial point, just for those who are in the UK, we have now a requirement to go through the pre-action protocol for the litigation. Obviously, in construction engineering, we have our own construction engineering pre-action protocol. For years, there used to be an argument that if you were going to sue a consultant for professional negligence, it didn't apply, but thankfully they've amended that protocol so that professional negligence claims also fall within the ambit of the construction engineering pre-action protocol. The problem with litigation, though, is it's lengthy, or can be lengthy, and certainly in jurisdictions outside of the UK, it seems that litigation can be incredibly lengthy and time consuming. We've become quite good here in the UK, both in arbitration and litigation, and indeed in construction and adjudication, speeding up the dispute resolution process. Because it can be lengthy, it's expensive, and in the court system, it's public. So also, it is hard to stop litigation once it's begun. Because people's views become very entrenched and very fixed, they really can become very difficult, which is where we'll get into the next topic on this slide, which is mediation. Got something about Part 8 and hybrid claims there. Really, that's for the English courts, where Part 8 is all about where the facts are not really in dispute, and then hybrid claims are mixed ones. Mediation certainly in England and Wales, mediation has become fundamentally important, and I know it's used very widely internationally. Often part of the pre-action protocol, effective only where the parties narrow the issues. There are some occasions where it doesn't, but the great trick to mediation, apart from choosing a mediator who has the right skill sets to deal with the particular parties, and I've seen some very, very different mediators, and I personally, when I'm trying to prepare for mediation, one of the most fundamental points in any mediation is who you choose as your mediator. Because once you've chosen your mediator, you need to know the parties, because certain parties will lend themselves to certain types of mediators, the type that will befriend you, as opposed to the one who will take you into a room and get you away from your lawyer and almost beat you to accept that there's a need for you to accept a settlement. But you've got to do those instances of significant power imbalance. So the next point here I want to talk about is arbitration, which is the private version of dispute resolution. Often considered, I'm probably showing my age and the number of years I've been doing this. Perhaps I started working as a solicitor when the Arbitration Act was young, there 1996. As you'll see in lower down the slide, Construction Act, or the Housing Grants Construction Regeneration Act, the period between 1996 and 1998 is an incredibly important period in the English legal system, because we also ripped up our old court books and replaced them with the civil procedure rules. And the reason I mention that now with the Arbitration Act, which is also, the Arbitration Act was about the UK trying to get rid of the old impression of the UK as being an arbitration unfriendly country for dealing with disputes that are non-UK disputes, because the court seemed to be quite interventionist prior to the Arbitration Act. And the Arbitration Act was to bring the UNTITLED rules into disputes, arbitration disputes, brought us in line with the international norms, and was designed to make the UK a more attractive country. So they're not just choosing English law as the law of your arbitration in international arbitration, but also choosing London as the seat of your arbitration. And harking mildly back to Brexit and COVID, just say London is still open for international arbitration. In fact, our courts are still just as friendly as they have always been to support the arbitral tribunal in carrying out their roles. In fact, the Arbitration Act significantly reduced the amount of grounds which a court could intervene. Really, the Arbitration Act creates a framework for the parties to be assisted in resolving their disputes and allowing the courts to, when required to intervene. There are very, very limited powers for an English court to overturn an arbitration decision. Depending upon what jurisdiction you're coming from, indeed, you come with a court decision or an arbitration decision into the UK, it's very easy to enforce against a party in the UK. They are binding results subject to the very limited right of appeal. The next topic, this is a thing that actually we should thank Sir Michael Latham for his report in 1994, building the team, which gave us the Construction Act of 1996, which was implemented in England on the 1st of May 1998 to all contracts entered into, and the scheme for construction contracts regulations, England and Wales, and there was a separate Scottish version, as the Scots have a separate system. Essentially, adjudication, which has found its way into most corners of the globe at the moment, perhaps not under the title of adjudication, but I'll mention that in a moment. But it has become fundamental to the English construction industry, the British construction industry. It's quick, it's relatively speaking inexpensive, although I've seen some very large adjudicators' bills. It's a miracle they can run up those bills in such a small space of time. And it's private. Unless the parties have to go off to enforce it, which the courts in the Technology and Construction Court, which is part now of the Business and Property Court in England and Wales, came up with a special system, specially to enforce adjudicators' decisions, which is supposed to deal with in 6 to 8 weeks. Construction Act, as I mentioned, brought about 1996. It was about cash flow. It was about, and it's probably the single biggest important item for keeping many construction companies afloat through the Act and the payment regime that was introduced, and also the system for dispute is interimly binding, but in reality 90% plus of adjudicators' decisions are actually binding. So if we have the next slide, please. International arbitration, I mentioned this note, so this is an international as well as a UK domestic talk webinar today. This may be selling ourselves, but London remains the most popular seat for international arbitration. We have phenomenal venues here for conducting arbitration. There's recently the IDRC has moved from its old location on Fleet Street to a location overlooking St Paul's as a venue. The courts are supportive thanks to the Arbitration Act. English arbitrators, common law arbitrators are incredibly skilled arbitrators. English common law is used as a basis for governing the law in many of the agreements, not least because many of them actually rely upon were drafted in this country. London is perceived as a neutral venue, and the courts seem to take a robust view of life. We've had the two recent cases, Halliburton and Chubb, which has been widely written about and reported on, which dealt with some fundamental issues of enforcement decisions for international arbitration. But the one I just want to talk about is the Cofley v Tony Bingham and Knowles. This is more interesting, but it shows how bias in arbitration is still looked upon by the courts and tribunals. It is notable because, if you're in the UK and you read Building magazine, you'll know Tony Bingham, but it's not so much for that basis. But it was because it came out during this case that Tony Bingham had acted in so many arbitrations, so that there was an implication of bias due to the simple fact that he earned so much money from the adjudications that he did and arbitrations that he did. And that it was that basis, and it all came out during the trial. And it's fascinating, something we probably don't focus on, that where there are adjudicators and so on. And we've had this whole thing with adjudicators and arbitrators in the UK about bias, because so many disputes are now resolved via adjudication and then potentially go on to arbitration, that actually you may have somebody who knows a party really quite intimately, but not openly knows them. And this is where this all came out, and this is where the bias issue came. Now this is, I'm going to hand over to Lachlan for an adjudication update.
Thank you, Richard. So, adjudication update. Is it the best way to get paid? This is the question. Well, it certainly remains a very popular method of securing funds. And as we say here, it has the description rough justice. There are ways to manage this. And of course, it doesn't have to be totally rough justice. How it can be easier, or indeed how you can make life more difficult for your opposition, in terms of the strategy there. As we say, obtaining expert evidence can be very difficult for a responding party in the tight timeframes. So of course, there is the advantage there if you're the referring party, you're bringing the dispute to adjudication, that you have the opportunity to get all your ducks in a row beforehand. And therefore the pressure is very much then on the responding party. So what should you be thinking about if you feel as though there's a dispute brewing? Well, first of all, you're going to need to make sure there is in fact a dispute, that there has to be a crystallized dispute. Otherwise, there will be the potential for, well, there will be jurisdictional challenges. And jurisdictional challenges are of course relevant to think about if you're the referring party, or if you're the responding party, to make those and to potentially derail the dispute from the get-go. Other considerations, that a nominating body occasionally acted both for and against architects, and If, of course, you're using a REBA standard form and they're the nominating body, and you're going against an architect, well, the chances are that you've got to bear that in mind. And if you get an architect as your adjudicator, you need to think about the consequences of that if you are not, in fact, the architect referring the dispute to adjudication. The nomination form as well, touching on that point, have a think about who you want. Obviously, you can't just out of the blue state we want this person, but you can if they have already presided over a previous dispute, because you can say that proportionately, in terms of saving time and everything else, they have the knowledge of that dispute, and therefore that a follow-up dispute should be conducted by them. And it's also worth thinking about the skills that you require of the adjudicator. And I suppose that feeds in to the next point, which is the complexity and the size, the quantum of the dispute. Is adjudication the correct path? Is it something that can be adequately resolved in the time frame? If it's a payment dispute or a payment default dispute, then the sums are to some extent less relevant, because the issues ought to be slightly easier than, say, a very, very detailed final account dispute involving extensions of time potentially and defects and everything else. So it's worth considering whether or not adjudication is the correct path in each case for each sort of dispute. Tactical advantages, of course, if you are the referring party, to some extent you're in the driving seat and the pressure is on the responding party to respond. So it does very much give you that additional pressure, which of course can be helpful in achieving settlement, although more on that on the next slide. The mistakes that we would discourage people from making: rushing in. It's very common. It's understandable. You're frustrated. You're owed money, and the temptation is to say, well, we're virtually there. Let's serve the papers. And of course, what we would say is get your referral drafted in advance of your notice of adjudication. Get the expert evidence, if there is any. Get your witness statements, everything else that you need together. And then you can start the proceedings with certainty that you're not going to be on the back foot. So that's one thing we would definitely see. And of course, not holding information, get it over to the advisors. We need to know where we are, and indeed where you are, and what's happened, and get the full view of that. And of course, in terms of the information that has gone to the other side, they're going to need to have seen it as well to ensure that there is actually a dispute here. So it's a question of that information and all the evidence. So, as I mentioned, adjudication can help in increasing the chances of settlement, and it's not uncommon for the notice of adjudication to be used tactically to kickstart some without prejudice discussions, and we've seen that happen ourselves with various phone calls happening after the notice goes in. The parties go, well, actually, I'm not sure I fancy my chances here, that this looks like a good claim, I better pick up the phone. A note on the fees as well. If there is a prior agreement to legal costs, obviously that can be taken into account, but traditionally it's costs following the event in relation to adjudicators' fees, and that tends to mean if you lose, you're paying for all the fees. In rare circumstances, there could be instances of apportionment if the adjudicator sees that as the right thing to do. Non-payment of adjudicators' awards, i.e. where the losing party simply chooses to ignore one, we haven't actually seen an increase in this and the need to go to enforcement. We have seen various adjudications that require further disputes being referred, but generally not parties that are just refused outright. So that is one plus point, which is perhaps surprising in the current climate. And of course, tactically, you can commence adjudication just prior to insolvency of the responding party, and that can be quite a good way to focus the mind and of course put the insolvency practitioner on notice as and when they are appointed. So perhaps a brief look at some important case law here. Grove and S&T, of course, went to the Court of Appeal and was heralded by many as the end of smash and grabs. Now, obviously, that's not happened. What it did do was to say that true value dispute can be launched in response. So smash and grabs are still happening, and so it's not, well, didn't have the effect I think that everyone thought it would, but it's no doubt very useful in saying that what you can do as long as you pay first and then argue later. Hybrid contracts are just worth touching on briefly, and MW High-Tech, that comes on the back of the previous hybrid contract case of Severfield and Duro, and that's all about what is construction operations under the Construction Act. And in summary, of course, the scheme and those payment obligations only apply to payments relating to construction operations. So the question before the courts was, well, must they be separately represented in payment applications? Do I have to break everything down for the different activities which don't fall within that? And the court said, well, you could, but the sensible thing to do is just to have everything there and to make sure that you adhere to the scheme with on both bases, and that way it's covered and the full sums are there and understood. Oral contracts, two important cases here relating to the repeal of Section 107 of the Construction Act 1996, which stipulated, of course, that only contracts in writing could be referred to adjudication. So the summary of these two cases is that whilst you can certainly adjudicate on the back of an oral contract, you may run into difficulty in enforcement, because in both cases the judges found that there was a strong possibility that there was a dispute as to the existence of the contracts, and therefore the defence ought to be permitted, and therefore that it wasn't suitable for summary judgment or enforcement. And then just a quick note on adjudications brought by insolvent companies, Bresco, Lonsdale, Cannon and Primus. In Bresco, of course, the Supreme Court, who handed down a judgment not too long ago, said that there was jurisdiction for an insolvent company to refer a dispute to adjudication, and that the court should only restrain that ability very, very rarely in exceptional circumstances, and that in fact the reference of disputes to adjudication will be useful for insolvency practitioners anyway, and that it was not an exercise of futility, which is how it had previously been described. These risks can of course be mitigated, the Supreme Court said, with the liquidator offering appropriate undertakings, such as payments in ring fencing, discussed in the case Meadowside. So I'm handing back over to Richard now, who's going to talk about getting paid in pressured times.
Indeed, thank you very much, Lachlan. Getting paid in pressured times. Actually, when I was re-looking at my slides this morning, it reminded me of, I have a client who I'll be speaking to probably far more than he actually wants me to be speaking to him at the moment. But one of the references I made was, it starts with a contract, it ends with a contract when it comes to what we're looking at when we're getting paid in pressured times. You need to know what your contract says. It's not good enough to be an old school contractor in these times, where if by chance you had signed your construction contract, you would then put it in the drawer and see how much dust you could get on it until there was a dispute, then bring it out and dust it off. Especially in more sophisticated contracts and projects, where it's simply you have to be on top of everything to do that. So in part, what I'm going to do is common sense. Now, these next few slides is all going to be some common sense advice, whether it be you're a contractor, you're an employer. These are the common sense things that you do, probably common law as much as anything. Obviously, in the shorter forms of contracts that you use in Europe and other parts of the world where you've got civil codes in place, obviously you have the advantage that you look to your civil code as well for how you interpret and how you address your contracts. The fundamentals: to start with the contract, end with the contract, read your contract, and know what the terms say and mean. So if you're going to get paid, or you're going to avoid paying, you make sure you follow the notice provisions in the contract. For example, termination. There's a lovely old English case about termination. It says essentially if it says it has to be printed on blue paper and you printed the letter on pink paper, it's not good enough. So make sure you read the requirements that you have. Mitigating your liability there, ladies. Make sure you submit your extension times claims and provide details of loss and expense as soon as possible. Remember, virtually all forms of contract have a requirement that the contractor shall provide this information, whether it be the JCT, whether it be the NEC, whether it be FIDIC. There's always provisions that require you to give this information. Obviously, NEC is a compensation event. But then there's a condition precedent, an express condition precedent in the NEC that requires you to give your notice. So make sure you have a look at them. And if there are amendments to the contract, you must read the amendments and make sure there's not something lurking in them that changes the way you have to give the notice and how you deal with them. Consider all bases of claim and express entitlements. And express your entitlement in every possible option it might be. I recently had a case where a party has written several years after completion and stated that only now have they worked out where they might be entitled to an extension of time. You have to ask the question, if it's only now and you finished the work years ago, why didn't you notice at the time? You need to have good records. You need to make sure you keep all of your records, keep everything in detail order, make sure that when you need to, you can actually produce that evidence. Whoever you're instructing, if you have poor evidence or poorly organized papers, apart from it will cost you more to fight a dispute, you will lose out on being paid for things because your papers are not in order. So make sure they are in order, and it's time consuming and it's painful. And make sure the other thing is, make sure everybody's laptops are backed up. I do recall a case, it was a fair few years ago now, but actually we lost the case, although not lost the case, but there were big issues with it because we were working on a site in an area of London where all but one member of the construction management team was mugged and had their laptop stolen, and they hadn't backed it up. You would be amazed how much data we lost, as a result of that. And it's those kind of things. Make sure things backed up. Make sure there's copies kept. Don't forget claims at common law. If they're not excluded by a standard form, you may have other options. Look at whether there are ways of elongating the payment cycles downstream. Fortunately, as someone who regularly acts, or fortunately, someone who regularly acts for main contractors and subcontractors, you will look at something and you will see main contracts, normal payment terms 14 days. Those payment terms are amended to 30 days. Down the line, we make them 45. Everything gets extended out, which is why obviously there's this whole perception of defeating the whole system by believing that the person least able to pay for it is funding the construction project. How many times have you actually, especially the little guy, you feel like you're the one who's being asked to fund that construction project? Bring a notice of adjudication to project meetings if it's got that, if you got to that point, or bring your referral to the dispute board with you. Bring your notice of arbitration, whatever it might be, to a meeting. Leave it on the desk, just so that somebody can see those words, draft notice of arbitration, draft dispute board referral, whatever, and just so they can see it. So if we can move on to the next slide. Avoid things like deemed acceptances. Make sure everything's referred to in writing, so that you've got a variation. Most contracts require that if a variation is going to be instructed, it has to be confirmed in writing. Many require that you can't have a variation until it is confirmed in writing. So you need to make sure it's done. Are there additional LAD provisions? Avoid wide construction notices and how they might be. So, you know, you can have LADs for floor area, everything else. Try caps on liabilities as potential amendments as well. Include projected final accounts into your application so that people know what your final account's going to be. Check what the waiver provisions are. Most amended contracts have a clear provision that says just because we waive it once doesn't mean it affects the future. So be mindful and check what the waiver provisions are under your contract. Carve out responsibility for ground conditions. Ooh, this is very topical for myself and Lachlan because we're working on a case at this very moment where ground conditions have come up, and working out what is the ground and what is below the ground at the moment. Ensure any side agreements are properly reviewed and incorporated into contract. Make sure you check for that entire agreement clause, because if there's an entire agreement clause in your contract, then you can advice. Now some advice from the employers in the room. If you're using JCT or if you're NEC or FIDIC or anything else, it's less of NEC and FIDIC because it already is. Make the program a contract document, but make sure it's updated. You know, it's a bit of a double-edged sword, but the whole purpose of, if you look at the NEC 4 and the NEC 3 and look at the latest versions of FIDIC with the provisions for the program, they're not meant as a tool with which to bash the subcontractor or the main contractor, whoever, really. Ultimately, the people who drafted them for, if we have these provisions, it should become pretty clear early on when the work's being delayed, so you can issue a compensation event, and the employer and the contractor can work together to try to do it. That's why you know, in a bigger project, programs are so very, very important, because you will get built up for you. If you have, and in many times we do it when we're amending the JCT contract, we bring in provisions similar to the NEC, and you know, you report against the program on a regular basis. But there are certain people I know who use various different phrases to describe it, but I'll use the clean version. Pour information out, pour data in, pour data out. To begin with C and S and all other different words. Those employers implement time bars to loss and expense. Just saying forthwith, shall, is never enough. Make sure they have to do it within a very restricted period of time. Use condition payment, precedents for payment, i.e. if you don't provide a warranty, 10% of the contract price or that particular consultant is going to be paid for, you know, make sure the contract's signed. Create a single point design responsibility. Generally, UK, internationally, sign and build, you pass it on to the contractor, because they're the ones who could best able to manage the risk. Because at the end of the day, we are talking about risk management to keep the cost down, to stop it running away from it. Use enhanced termination step-in rights. You know, step-in rights are for funders and other people, but enhanced termination rights, termination at will. Make sure that you have the most up-to-date deleterious material clause. Make sure there's a reference to specification and downstream usage. Yeah. Then in retaining the money, advice for increase the standard of care. The Hogard case over the wind turbines and how the contractor got away there. Make sure you have a high level of standard of care required. Restrict, amend the relevant matters and compensation events that might lead to money. Reduce the effect of any approval, i.e., you know, an approval is not an approval as such. It is just sort of a nodding acceptance. Okay, you've done the work. It's not saying that it is done properly or anything of that nature. Make sure you incorporate a formal snagging process into your contract so that you know, and a time frame for completion of snagging. Depending upon what the project is, you may wish to have things dealt with more quickly or more slowly. Responsibility for site conditions. Well, let's face it, every bit of advice here for the employers: make the contractor responsible for site conditions, but do it properly. Under the unamended forms, site conditions are generally the problem of the contractor, but it may not be fully passed over to them, so you have to manage that very carefully. Remove references to common law rights being there. Exclude them if you possibly can. Exclude and limit everything that you can with the exception of death and personal injury and fraud. Manage how you organise it. Create disentitlement CAT where there's concurrent delays, or at the very least loss and expense where there's concurrent delays. Although arguably if you're running a JCT contract, you don't have to actually pay loss and expense where there's concurrent delay, but you've got to prove it. Going back to the use of a program. Outside of building contracts, I put here letters of intent. Don't do it unless you really have to. I've done one in the last few weeks, but you almost put a public health warning as big as the one on the pack of cigarettes for smokers on a letter of intent, for everybody, because they'll come to an end at a specified time, a specified value. You generally draft them properly so they incorporate the original version of the schedule of amendments. If that schedule of amendments is more onerous, if you're the employer, you might actually want to keep them in a letter of intent. It might be the odd contractor who makes a mistake to keep on working. You stop paying them because you reach the value, but they keep going. Yes, there are ways and means. Bonds, make use of bonds. I'm not the biggest fan of bonds, I have to say. I find that on-demand bonds tend to be rejected by insurers. Bonds for retention, it just makes life harder, because the reality is if you keep a retention, you put in a clause within your contract that says you have no fiduciary duty, no obligations, no anything, so you can basically spend the retention on anything you like. But vesting certificates for materials, just in case somebody goes bust. In these present times when you're trying to retain money, even with, in many countries, especially certainly in the UK, you've got the restrictions on for COVID and protection from insolvency. To be honest, I see people trying to get around those rules all the time at the moment. And now I'm going to hand over to Lachlan.
Thanks, Richard. So how to protect yourself against insolvency issues? Obviously, we've been mentioning insolvency, and of course, as Richard said, mentioned the moratorium for winding up positions has just been extended to June. Unfortunately, as Richard said, people are tending to think, well, I'll just go and wind up business anyway and try to get around. But anyway, how can you protect yourself against these insolvency issues? Well, with some, I don't think this is necessarily a bad thing, but it seems somewhat ironic that perhaps some planning for Brexit might actually have gone somewhere already to assist companies now in defending themselves against these insolvency issues, because things like business continuity and governance, two very important areas for any business, of course, these would have been looked at, or hopefully will have been, for Brexit, and of course that will then assist in terms of dealing with insolvency. So what specific things can you do, and what should you be potentially looking at? So force majeure, as we discussed earlier, get those events defined, have the list so everyone knows exactly what they're doing. The greater degree of clarity that there is, the better it is, because people know where they are. So what are those events, and what are the payment obligations during the course of that event? Of course, if the idea is to protect against insolvency issues, the last thing you want to do is to completely starve a business or be starved. So the idea is that taking a sensible approach to this, to have a system in place that works. Grace periods as well are very important. In the same way that you want your payment obligations there, you also want a grace period, so that there isn't the pressure then, and there is time to say, well, look, we're doing our best and we can bring this around, and we don't need to be terminated, or we don't want to be terminated. And of course, as part of this, you're going to want to give a duration and deal with the expiry of these qualifying events, and that's traditionally something that isn't hugely well dealt with in a lot of bespoke drafted clauses. So something to think about there as well in terms of again, that clarity. and of course how force majeure and those provisions will interface with termination. Ditto insolvency issues as well. Of course, some people, as we mentioned with the enhanced termination rights, you could be amending your contracts to say, well, in the event that there's anything, any payments missed downstream, that then is proof of main contractor insolvency, things like that. These provisions are quite tough potentially, but there's certainly ways and means of getting that effective early warning of insolvency. And of course, as I mentioned, early warning, you could be requesting forecasting obligations, so you get an idea of the health of your counterparties. In terms of the other documents, if you've got things like exclusivity agreements, very important to check that if a supplier goes bust, can you approach an alternative supplier? Obviously, it would be a sensible thing to do so, but you don't want to find that you're unable to do so. And there are some instances of going that bit further, in fact, and saying, well, if the supplier's gone bust, say, or they're struggling, can you actually go there? You could potentially use their plant. I've seen that being suggested, know how and collaborate on that way as well. So it's not a guaranteed delay and a huge problem at all the cost of finding an alternative supplier. And of course, worth reviewing the bonds as well. As Richard said, they can make life a bit harder, but nonetheless, good to know exactly where you are. Do you know whether it's an on-demand bond or a default bond, etc., etc. And of course, if you are in financial difficulties, then selecting the right process for your then to go on to solve any disputes. So these are some sort of obvious pointers in terms of what you could be looking at to protect yourself against these insolvency issues. Is termination the best thing to do? Well, just because you can, should you? And I think the temptation is often to say, well, look, here's a clear contractual right, I want to exercise it and where I'm going to go. But potentially take a step back and think, is this right commercially? What do I stand to gain from doing this? Can I work together potentially with the other party, or what other options are there? Pricing the job correctly and interrogating low tenders. Well, this is very important, and actually one of my more memorable cases all arose from a job which had been priced, I think it was a 7 figures, the lowest bid was 7 figures less than the next one. They were also clumped together, and it was a complete disaster. And unfortunately, the naive developers thought, oh, well, that must be value. And of course, it wasn't. And it spoke volumes as to the contractor's intentions, frankly. Payment cycles and waiting, well, that's sort of the reverse of what we were talking about earlier in terms of managing the cash flow over a project. And of course, escrow accounts as well, project bank accounts, important to have those, as well as looking out for behavior, rumors, filings, what appears to be going on. Keep an eye on that, because that may inform your knowledge of someone's potential insolvency. Where an employer is insolvent and the contractor is the largest creditor, you can then potentially influence the appointment of a liquidator as well, get them kicked off, get your own ones in, etc., etc. Richard's touched on pretensions of title, and of course, adjudication prior to insolvency remains an option as well. So, some questions here. Richard, I think you've got the first question.
Indeed, thank you, Lachlan. First question, and Dan, if there are any questions that have come through, do just let us know. We've got some pre-submitted questions to kick off with. The first question we had was, what are the expectations of panel members in terms of performance guarantee requirements during the post-COVID-19 era? It's an interesting one. Yeah. What increasingly, my view of this is that the performance guarantee requirements are probably going to change very little in the post-COVID-19 era. I think we're going to actually find that, survival of the fittest, as it were, which may be inappropriate to say, but those companies that are most best financed and so on are actually coming out of this really okay, not brilliant, but they're making profits, they're making money, the industry is keeping on going. So I think that actually performance guarantees, they may become harder to get because as the banks and insurance market has tightened up, but I think that they're going to be able to continue, and I don't think there's going to be a massive change. So I think then we've got a second question, which is over to you, Lachlan.
Yeah, thanks, Richard. So the next question that we got in was particularly interesting for me anyway. So which step in the construction process gives rise to the most disputes? Hilariously, the person said, don't say getting paid. And which step in litigation? So I think Richard and I both agree that in terms of the most contentious aspect to construction, extensions of time, perhaps unsurprising given the current climate, and of course the bun fight over who's going to bear the risk for the delays of the last 18 months or so, and final accounts as well. Quite often there's going to be a big difference between the parties, and of course it's resolving that with all the claims for EOTs and delays and everything else going alongside that as well. In litigation, well, we would say that settlement discussions remain very tricky. It's difficult to, you've got to narrow the issues, you've got to remove the egos, and knowing when to push and knowing when to take a step back and perhaps reevaluate that is quite challenging. And of course, that pre-action protocol meeting, as we mentioned earlier, can be very fruitful, but depending on the parties, can be very difficult. And it's knowing, how hard to push there as well. So yeah, that's our answer to that one. We were also asked, how best can we find an exit from a contract due to COVID if the contract doesn't specifically mention have any pandemic provisions? Well, clearly in that case, you can't rely directly or strictly on using COVID, but look for some other options. Is there anything about force majeure that you could kind of bend to that? Are there any options there? What about frustration? Have you considered that? And are there any potential opportunities for a common law termination under some other bases too? And I think Richard's got another question over there.
Yes, I'm just going to make an additional observation on the question about exit from a contract where the JV. Obviously, UK law, yes, common law, but if you're in a civil law jurisdiction, force majeure is, of course, a defined term. So you're dependent upon what the particular code provides. There may be some additional assistance there. On to the next question. Why EPC contracts have so many unresolved points, especially risks and what to do? Well, interesting. EPC projects are incredibly complex beasts as it is, and it's so difficult to actually see them, and that's part of the reason why there are things like caps on delay damages, and far greater attention is paid to who design risk and how that design risk can be carried out. But the most fundamental, in my view, in any EPC contract, most of which are under some form of any amended NEC or FIDIC contract, is to have a risk register at the outset and try and assess as many of those possible risks as possible and assign them to a party. Once you do that, then you're in a position where you've got proper risk allocation and people can manage that risk, and the right party hopefully will manage that risk and be able to deal with it. So that I think that why EPC have so many unresolved issues is simply the complexity of the issues that you have to deal with and the duration of the works that you're going to be actually working on. And the truth is, if you look at some the Broadgate Tower in the city is 70 odd stories. That took years to get off the ground, literally. And it's been incredibly complex, and they've had to change it several times. There's been loads of problems in it, many of which were unforeseen. So again, they could have done with a risk register. Then another question is over to you, then, Lachlan.
Yeah, so So two quick ones. Can we no longer blame disruptions on force majeure since the increasing pressure is still as a result of COVID-19? Well, hopefully we've touched on this in the talk. And of course, things to consider are going to be, the direct effect and the loss of capability arising from COVID in terms of completing your obligations. Has that completion become more difficult or radically different? Those are the kind of questions you need to be considering. And another one in 2, if a firm in the UK breaches an agreement with a Nigerian company and they get a good judgment in Nigeria, what happens next? Well, you could enforce that judgment in the UK pursuant to the Administration of Justice Act 1920, subject to doing so within 12 months of that judgment, and also being able to satisfy English courts that there was no likelihood of an appeal, as that would potentially prevent the enforcement. So thank you for that question.
Okay, and our final question before we wrap up. Where is collaboration and common sense? It's an interesting question. Common sense is something I always ask my children about. Where is the debate heading, whether COVID-19 is a change of law or not? Well, it's temporarily, depending upon where you are in the world, it has been a change of law. But those laws are probably going to revert back over the next few years anyway. I mean, the debate's already ongoing here as to how soon you reopen, how soon you get rid of all the emergency laws that were passed. I think that in reality, for the next year or two, we're going to have disputes that have relationship to COVID. There's also a whole issue about what was COVID, what's disruption caused by the government's response to COVID. You might have had a site closed because of COVID, but you might have just because you simply, the way in which you have to do the work's changed, because you can only get 50 people on site, so 250 people on the site. Is that COVID or is that a change of law? So I think there's lots of different options there, and it's really going to depend upon what the contracts are. What I will say is, as someone who regularly reviews and drafts contracts, there are significant changes to contracts with COVID provisions. But in 2 years' time, I think those COVID clauses will be gone because we won't need them anymore. So that would be my answer to that question. I'll just check with our moderators whether there are any more questions. Otherwise, I think that will bring a close to the webinar. There are slides available. There's a couple of slides that follow this to give you some outline and services that Goodman Derrick can provide to you as potentially we could work together. If there are questions, our details are there. After this, drop one of us an email, give us a call. We'll be happy to discuss that with you. But otherwise, I'll hand back to Dan and say thank you very much for attending today's webinar.
Thank you very much for that, Richard. I just want to say, just to reiterate what Richard has just said, if you do have any further questions, please do send them in to the team. They are more than happy to get back to you. I want to say on behalf of everybody at Mondac, thank you very much to Goodman Derrick, to our wonderful panel, Lachlan and Richard. Really insightful, knowledgeable webinar today. I think that we're all a lot more knowledgeable for having listened today, so thank you for that. And of course, thank you to our audience for joining us today. As we've said, if you do have any questions, if you want to follow up with Lachlan and Richard, you have their details available, and we will be following up with you tomorrow with an on-demand version and everybody's contact information and the slides if Goodman Derrick are happy with that. So once again, thank you for joining us. I hope you all have a lovely rest of your day. Thank you very much.